So, the Supreme Court has just issued an 8-1 emergency decision that's sending shockwaves across the country, especially for those following the ongoing fight over the Second Amendment Preservation Act, better known as the SAPA law. This latest ruling marks a turning point in how states can challenge federal firearm enforcement and could reshape the balance between state sovereignty and federal authority. So today we're breaking down exactly what this 8-1 decision means, how we got here, and most importantly, what happens next in the battle to preserve Second Amendment rights in America. Before we dive deep into this massive legal update, I just want to take a quick moment to ask for your support. If you're someone who believes in staying informed about how the courts shape our freedoms, make sure you're subscribed to the channel. YouTube sometimes unsubscribes people, so double-check that you're still following us and that you've turned on all notifications so you don't miss future updates. It only takes a second, but it really helps us reach more viewers who care about the Constitution, individual liberty, and the rule of law. Also, a quick thank you to one of the supporters of this channel, companies who continue to stand by the principles of freedom, responsibility, and the Second Amendment. Supporting them supports independent reporting like this one. You'll find their links below in the description and pinned comment if you'd like to check them out. Now let's get into the facts. This case revolves around Missouri's Second Amendment Preservation Act, a law passed in 2021 that set the state's own interpretation of the Second Amendment. In essence, the law declared that Missouri would not cooperate with federal authorities in enforcing federal gun laws that the state deemed unconstitutional. It also created a civil penalty, allowing any citizen to sue state officials if they helped the federal government enforce laws that went against Missouri's reading of the Second Amendment. In other words, Missouri was saying, we're not going to let Washington use our officers or our resources to go after lawful gun owners under laws that we believe violate the Constitution. Almost immediately after the law was signed, the Biden administration's Department of Justice filed a lawsuit against Missouri, arguing that the state couldn't simply ignore or nullify federal law. The case went before a district court where the federal government won. The judge there struck down the entire SAPA law, saying it was unconstitutional and violated the supremacy of federal law. That ruling effectively blocked the law from being enforced, at least for the time being. Missouri, refusing to back down, appealed the decision to the Eighth Circuit Court of Appeals, arguing that the federal government had overstepped its bounds and that states have every right to decide how they use their resources. While that appeal was still being processed, Missouri also filed an emergency request to the U.S. Supreme Court asking for an immediate stay. In other words, asking the court to allow the SOPA law to stay in effect while the case worked its way through the courts. That's where the first major moment came. The Supreme Court issued an 8-1 decision denying Missouri's emergency request. Only Justice Clarence Thomas dissented, meaning he was the sole justice who believed Missouri should be granted temporary relief. While the case continued, every other justice agreed with the denial. Now, at first glance, that might seem like a loss for Missouri and for supporters of state-level Second Amendment protections, but it's not quite that simple. The court's denial of emergency review doesn't mean the justices believe the SAPA law is unconstitutional. It simply means they didn't think this was the right time to intervene. The Supreme Court often denies emergency petitions when it wants the lower courts to fully process the case first, especially when the facts are still developing. That's why this new 8-1 emergency decision is so critical. It signals that while the court isn't stepping in yet, it's closely watching what happens next, and that's exactly what we're going to unpack now in this latest order. The Supreme Court once again refused to take up emergency review of the SAPA case. But what's important is what happens next. This denial effectively sends the case back down to the lower courts, where the fight over Missouri's law will continue and where some surprising developments have already started to unfold. See, when the case went back to the district court, the federal government, now under the Trump administration, made a significant move. They indicated that while they still believed parts of Missouri's SOPA law might conflict with federal authority, they were willing to partially release some of the judgments that had been obtained under the Biden DOJ. In simple terms, the Trump DOJ said, We think the previous injunction was too broad, we'll lift some of it, and let parts of Missouri's law go into effect. That's a major shift, because what it means is that even though the Supreme Court denied immediate review, the state of Missouri could still begin to enforce parts of its Second Amendment Preservation Act while the legal battle continues in lower courts. Now, if you followed this channel for a while, you know this isn't just about one state. This case could set a national precedent, determining whether states have the right to resist federal firearm enforcement they see as unconstitutional. If Missouri ultimately prevails, it would give a green light to other states across the country, Texas, Florida, Arizona, and more, to pass similar softy laws. And if that happens, it could fundamentally change how federal gun regulations are enforced nationwide. Let's take a step back and talk about why this law is so controversial. The Biden DOJ's argument has always been that the supremacy clause of the Constitution means federal law overrides state law. In their view, Missouri can't simply decide that federal gun laws are invalid and tell its officers not to help enforce them. They say that kind of action disrupts national enforcement efforts and creates confusion for law enforcement agencies that work together across state and federal levels. But Missouri argues something very different, and something that many constitutional scholars say is entirely legitimate. The state isn't nullifying federal law, it's simply saying, we don't have to help you enforce it. There's a key distinction there. States can't stop the federal government from enforcing its own laws, but they also can't be forced to use their own state officers or resources to carry out federal enforcement. That principle is known as the anti-commandeering doctrine, and it's been upheld by the Supreme Court multiple times in other contexts, such as marijuana laws and immigration policy. So in that sense, Missouri's position is built on existing constitutional precedent. But as we've seen, how courts interpret those limits can depend heavily on this specific case and the current political climate. And that's what makes this 8-1 emergency decision so fascinating. It shows that even within the Supreme Court, there's a recognition that this issue is complex and not ready for a final ruling yet. Justice Clarence Thomas's lone dissent is also worth noting. Thomas has long argued that the courts should be more aggressive in protecting state sovereignty when it comes to enforcing the Bill of Rights, especially the Second Amendment. His dissent suggests that, at least from its perspective, the state's right to shield its officers from federal enforcement deserves serious consideration. Meanwhile, back in Missouri, officials have celebrated the partial progress as a small victory. It's about whether states still have the power to stand up for the Constitution when Washington goes too far. So as we close today's video, remember this: the Supreme Court's 8-1 emergency decision isn't the end of the story. It's the beginning of the next chapter. The fight for the Second Amendment, for state sovereignty, and for the preservation of individual rights is alive and well. And as always, we'll be right here covering every turn, every filing, and every ruling that defines the future of your freedoms. If you found this breakdown helpful, hit that like button so this video reaches more people who care about the Constitution. Subscribe for ongoing coverage of Supreme Court rulings, Second Amendment updates, and all the major legal battles shaping America's future. Because as we always say, this nation was built by those who stood up for their rights, and it will be maintained by those who refuse to back